it is with immense honor, profound respect that I stand before you today at the Dr. Ashok Kumar Mohapatra Memorial National Moot Court Competition 2023. Today, we are privileged to welcome Mr. Prafulla Kumar Ratha sir and Mr. Rudra Prasad Kara sir, both distinguished senior advocate of Orissa High Court. They both graciously agreed to adjudicate this round of our moot court. Their presence here is not just an honor, but a testament to the high standards and the spirits of the excellence that the competition embodies. On behalf of the Dr. Ashok Kumar Mohapatra Memorial Committee and all the participants, I extend our heartful gratitude and warm welcome to our esteemed judge. Your presence elevates this competition and inspires us all to strive for the highest ideals in the future. Your Lordships, before going into the round, I just want the volunteer want to convey that AKM 11 are the petitioners and AKM 4 are the respondents. The total each team will be getting 30 minutes to represent their case, whereas speaker 1 of petitioner will be taking 17 minutes, whereas speaker 2 of the AKM 11 will be taking 13 minutes, and they are having 5 minutes for the rebuttals. And respondents AKM 4, speaker 1 will be taking 15 minutes and speaker 2 will be taking 15 minutes. Along with, they will be having 5 minutes for the rebuttals. With the permission of this honorable court, the volunteer seeks permission to proceed with the organized competition. Much obliged, your lordships. Much obliged. So
May the council begin.
Yes.
If it pleases this honorable bench, this council would like to address this bench collectively as lordships.
Yeah.
My lordships, there are two PILs which have been clubbed together by this honorable Supreme Court. They are Monica and Chandler versus Union of Silverland and One Code Movement versus Union of Silverland and Silverland Religious Group. If the honorable bench is well aware of the statement of facts, this council may proceed to the statement of jurisdiction.
No, as you like. It's up to you to address the court in the manner you like.
My lordship, I shall move to the statement of jurisdiction. The petitioners have approached this honorable court under Article 32 of the Constitution of India. My lordships, there are 5 issues in this case, and the first 2 issues shall be dealt by this council, and the last 3 issues shall be dealt by this council's co-council. If the court permits, the council shall proceed to issue number 1.
Yeah, please do.
My lordship, issue number 1 deals with whether both the PILs are maintainable in the court of Silverland or not, and is it feasible to implement UCC in a nation like Silverland. My lordship, the PIL concerning same-sex marriage is very much maintainable in the land of Silverland because Part 3 of our Constitution enshrines us with our fundamental rights, and Article 32 comes as a remedy whenever our fundamental rights are breached. My lords, right to approach to this honorable court is itself a fundamental right we have been given, and the court has the power to issue directions or orders or writs for the enforcement of these rights. My lords, the doctrine of separation is very well known to everyone, but the doctrine of judicial review, as was mentioned in Keshwanand Bharti versus State of Kerala, WPC 13 of 1970, plays a very crucial role here. Previously, this honorable court has used its power under Article 32 to enforce fundamental right whenever there was a legal vacuum in this aspect. My lords, in the case of Vishaka and others versus State of Rajasthan, this court had provided guidelines for this aspect even when there existed no laws. Not only can it not only the powers of this court extends to the striking down of offending statutes, but also it has the power to issue directions and give effect to the fundamental rights of the citizens, my lordship. My lordships, here the petitioner enjoy the stand of locus standi here, which talks about the doctrine of locus standi, which speaks that a person whose legal right has been violated and that person and the aggrieved party against whom a decision has been taken, that person has a very much right to bring an action in the court for his or her fundamental rights, my lordship. My lordship, the PIL is not only concerned to a private party or Monica and Chandler. My lords, the PIL is here representing the whole community of LGBTQ community. Hence, we want you to recognize the same-sex marriage only, like you have recognized in every other cases as well. Hence, the petitioners in this case were not allowed to register their marriage by Center Park's administrative body, which is a violation of their fundamental rights under Article 14, 15, 19, 1 and 21. Hence, this PIL is very much maintainable, my lordships.
One just query.
Yes, my lordship.
See, as you said, the fundamental rights can be enforced under Article 32 of the Constitution, and you have referred to the judicial review. Is that the only remedy under the Constitution for addressing the issue of PIL with regard to fundamental right, or there is any other remedy also, and any other provision also?
My lordship, Article 32 is the heart and soul of the Constitution, which is there whenever the fundamental rights of the citizens are hampered. It provides rights. My lordship, in Article 226 also, there is a provision to move to the High Court whenever
Correct.
there is a breach of fundamental rights.
Correct. Can you tell me the full form of LGBT abbreviation?
Yes, my lordship. My lordship, LGBTQ stands for lesbian, gay, transgender, bisexual, and queer community, my lordship.
Correct. Go ahead.
May the council proceed, my lordship.
Yes.
My lordship, the PIL concerning formulation and implementation of UCC is again very maintainable. This is regarding UCC, my lordship. My lordship, Part 4, Article 44 of the Constitution talks about the DPSPs, my lordship.
Subject to the learned senior counsel, Mr. Kar. You can proceed to the next issue. Skip over the maintainability point.
Yes.
Proceed to the next issue.
My lordship, can I take just 30 seconds in this, my lordship?
Okay, let her proceed in her own way. That will be better.
Okay.
Thank you, my lordship. My lordship, here, DPSP, the main object of DPSP was for the welfare of the society, my lordship. It is the state's obligation to do certain things in the welfare of people. So, UCC is a matter of equality, my lordship. It talks about treating every religion, every person of every religion equally, my lordship. And here, not treating anyone or everyone under equality violates Article 14, my lordship. As it was observed in the case of Sharla Mudgal versus Union of India, AIR 1995, SC 1531, it was observed that the lack of UCC is a major hurdle for the achievement of gender equality, my lordship. And it's a fundamental, there is a violation of fundamental rights of women. My lordship, the council would like to quote Dr. B.R. Ambedkar's legislative parliament debate that he said a government which rests on the popular vote can hardly ignore the directive principles while shaping its policy. And any government who does that is certainly answerable to the electoral during the election time, my lordship. This court has time and again set the parliament for the implementation of UCC, and the state being lethargic in this aspect is not only a contempt of this court but is a contempt of the constitution, my lordship. My lordship, the next thing talks about is it feasible to maintain UCC? My lordship, as I said, it talks about equality, and the concept of equality is very much enshrined in our preamble. My lordship, it also addressed gender inequality. My lordship, women of Muslim community face a lot of discrimination where their male counterpart is allowed for polygamy and everything. They do not enjoy that right. It's not about enjoyment. I apologize, my lordship. It's not about enjoyment. There are two differences between both the genders of the same religion here. So, my lordship, the implementation of UCC will bring a gender equality in this case. My lordship, it was held in SR Bommai versus Union of India that the constitution upholds the principle of secularism, my lordship. And as a matter of fact, Port Bay, a state in this country itself, has already implemented UCC. So it will be a matter of prudence to say that it is impossible to implement UCC in this country, my lordship. If the bench allow, if the lordships allow, the council shall.
I just have one question.
Yes,
How do you correlate UCC infringement with marriages of queer people? How are they too common? What's the commonality between the two?
My lordship, I would like to mention one thing here, that the PIL concerning same-sex marriage is on the behalf of Monica and Chandler, and the PIL concerning for UCC is on the behalf of One Court Movement, which stands for championing the Muslim women's rights. My lordship.
Do you think that these two EPLs should be clubbed together?
Indeed, my lordship, they are very much they should be very much clubbed together, as it is a matter of equality, my lordship. So I don't think it would be not legible enough not to club the petitions.
Okay, okay, proceed, please proceed.
Thank you, my lordship. My lordship, moving to issue number 2, it is asked whether same-sex marriage can be recognized legally. Does the constitution protect their rights? My lordship, denial of their legal recognition of their marriage is a breach of their fundamental right under Article 14. My lordship, Article 14 provides for equality and equality before law and equal protection. And like should be treated alike and unlikes should not be treated like alike. In order to give unequal treatment to a particular class of people, it must pass through two tests of reasonable classification, that is intelligible differentia, and the differentia must have a rational nexus with the object sought to be achieved. It was stated in the case of state of West Bengal and Bengal versus Anwar Ali Sarkar 1952 about the regional classification, my lordship. And here there is no regional classification with a rational nexus or objective nexus for not including the LGBTQ community under this. My lordship, making improper discrimination and denying the rights of a certain community is a sheer example of class legislation, which is completely forbidden by Article 14. My lordship, the concept of SMA, Special Marriage Act, was added to our country for protecting the plurality and the homogeneity of this country, for making marriages which were not socially acceptable at that point of time. My lordship, but Section 4, Section 4C, specifying the age of male and female in this aspect should mean the gender they identify with, and not the biological term we have been thinking about the man and women, my lordship. My lordship, not only that, Article 15 is also violated, which says that the state shall not discriminate any person on the basis of sex, but denying marital recognition just because of and the right to marry of one's choice based on someone's sexual orientation is a complete violation of Article 15, my lordship. In the case of Nalsar versus Union of India, this court recognized the third gender, but now they are not giving rights which are consequential to such recognition, denies the judgment odious, my lordships. They don't even have a they don't even come under the prohibited relation, my lordships. My lordships, Article 19(1)(a) talks about the freedom of expression and speech. My lordship, it is a necessary corollary that the right to be able to express someone's personal preferences in terms of choices. My lordship, they are unable to express their desires in terms of speech and choices, etc. There is no form, there is, my lordship, in the case of Navteej Singh Johar versus Union of India, the court declared the right to form unions, but my lordship, there was no right to form unions, but my lordship, without any other rights which arises from it. So my lordship, what is the real motive of identifying them if you're not giving them certain rights attached with it? My lordship, not only that, the Article 21 of the petitioners are also breached here, which talks about my lordship, the exclusion of same-sex people or marriage sends the exclusion of same-sex marriage from certain aspects sends a public message about their inferiority, about their worth unequal to the other counterparts of the society. It is just like as the case it happened of people not being allowed to a temple of certain castes, my lordship, which was a complete violation of the rule of the law of this land, my lordship. I would like to say the case Puttaswamy versus Union of India, where this honorable court had been intellectual and wise enough to acknowledge the rights of privacy and dignity, personal autonomy and quality, a life as facets of right to life and personal liberty under Article 21. In spite of that, the legal recognition of marriage among queer community renders the wide scope of Article 21, my lordship, and it is quite obvious for the queer community, which amounts to the blatant infringement of Article 21 as well, my lordship. So, my lordship, the statutory recognition of LGBTQ persons is merely a consequence of this court's jurisprudence only, my lordship.
One just, Madam Speaker,
Yes, my lordship.
are you of the view that uniform civil code, which you are saying should be uniform, has any nexus with the personal law? That whether, I mean, do you mean to say that this whole country, whatever diversities we have within us, like Muslim, like Christian, like Hindus, Persian, Jews, all of them should have one law with regard to marriage? Are you just conversing that all these should have an uniform law with regard to solemnization of the marriage in this country? What's your opinion about that?
My lordship, the implementation of UCC has nothing to do with the religions or the religious beliefs of the
Not
people.
religion, marriage.
Yes, my lordship, UCC shall deal with secular activities like maintenance, inheritance only, my lordship.
So you are
Of
saying
course,
huh.
my lordship, a Hindu person won't be forced to marry under nikah, nor will be a Muslim person said to do sindoor, my lordship.
Then
This is what.
how are you conversing these two things, personal law and UCC? How do you reconcile these two?
My lordship, because in this aspect, my lordship, in the case, as I said, in case of secular nature, my lordships, I am talking about secular things, my lordships.
Okay. So the marriage is a fundamental right.
My lordship, right to marry is simply an incidental and consequential right springing out from the recognition and decriminalization of the same sex relation, my lordship.
Directly coming to the point, whether marriage is a fundamental right.
My lordship, marriage is a very my lordship, marriage is a consequential right which has arrived from a fundamental right only, my lordship, which have been granted.
Yes or no?
My
Whether
lordship,
it's a fundamental right, yes or no?
my lordship, it does come under right to life and liberty, and
Correct.
I believe that the right to choose one's partner ultimately.
You can little magnify it, saying that right to life is a right to meaningful life. It's right to life is without a meaningful life is no life. So
Indeed.
you wanted to tell this should be in a little clear way, correct?
Indeed, my lordship.
Go ahead.
It was an honor learning from this court, my lordship.
Go ahead.
My lordship, issue number 2 ends here.
Correct. And in a lighter vein, just see the coordinator has violated the fundamental rights at part 3 here. Just see, sir, I am addressing to my learned brother, Mr. Kar.
Yes, sir.
They have violated the part 3 of the constitution. Here they have created clearly inequalities between you and me. They have provided you a cup of tea. I am deprived.
No, no, sir. I am just provided with a glass of water. I'm waiting to enjoy a cup of tea with you.
Okay, then I take back my statement. Okay.
Thank you very much.
My lordship, if the court is satisfied with the submission of issue number 1 and 2, this council's co-counsel shall come to deal with the rest of the
Time is
issues.
over. The coordinator has already said your time is over, so we should.
My lordship, it was an honor submitting before this honorable court. Thank you.
In each other speaker, one time is over. If the honorable court.
Your Lordship, Council seeks the permission to begin with issue number 3.
Number 3, yeah, please. She has completed, no?
No.
Issue number 3, the earlier speaker has said.
No, she is confining herself to issues 1 and 2.
Correct.
So let us hear gentleman who wants to address the
Issue number
addresses
3.
on issue
Go
number
ahead,
3.
go ahead, mister. Go ahead.
Much obliged, Your Lordship. Your Lordship, Uniform Civil Code does not infringe upon the fundamental rights and personal rights of its citizens because UCC is a necessity and it is the duty of the state to secure for its citizens. Moreover, it was held by Justice Y.V. Chandrachud in Shahbano case that UCC can act as a cause of national integration by removing the disparate loyalties to the laws which have conflicting ideologies. The UCC also does not infringe the fundamental rights guaranteed under Article 25 and 26. Your Lordship, in Sarla Mudgal versus Union of India, it was held that marriage, succession, and like matters of the secular character cannot be brought within the guarantee enshrined under Article 25 and 26. Your Lordship, therefore, Article 25 and 26 merely protects the right to practice rituals and ceremonies, etc., which are only integral part of the religion. Hence, they do not apply in this case, and for the same instance, Article 26 won't be applicable in this case. Your Lordship, uh, um, the UCC does not also overreach the personal rights of the citizens, as held by the doctrine of harmonious construction, that when in an enactment, any two of its provisions are in conflict with each other, it must be constructed in such a way as to create a balance between them. And here, by the doctrine of harmonious construction could help that the directive principles and fundamental rights can be uh, constructed in such a way that the legislation can achieve the goal of public interest. Your Lordship.
Sir, can I just stop you for a moment here?
Indeed. Yes, yes, Your Lordship.
If I am not wrong, my learned brother will say that both of you have not even placed your facts till now. Facts, what is a fact? There can be no law without a fact, and both of you have not yet placed your fact here in this case. Can you just submit the facts? What is that has happened here, which has instigated you to move this case? You have not even stated. The speaker number one directly went to the jurisdiction point, and thereafter issues. Facts you skipped over. You take your time, at least 1-2 minutes after he completes, to place the facts. Correct?
Indeed, Your Lordship.
Yes.
You have enumerated the facts, I think, at page 8 to 9.
Yes.
Yes, Your Lordship.
Why don't you begin with that? Or you allow your co-speaker to address the court on those facts at page 8 to 9 after you complete.
Indeed, Your Lordship.
My lordship, whatever the court wants, we can do that. I can say the statement of facts right now, my lordship.
Okay, let him complete.
Indeed, my lordship.
Your Lordship, it was held in Constitutional Assembly debate, page 540, that the UCC won't even abrogate the personal laws as secular activities such as inheritance, marriage, covered under personal law should be separated from religion, and moreover, it would also help in the promotion of national unity. Your Lordship, in Muhammad Hanif Qureshi and others versus State of Bihar, it was held that the directive principles are fundamental in the governance of the country and it is the duty of the state to give effect to them. Moreover, in the S.R. Bomai versus Union of India, it was held that religious is a matter of individual faith and cannot be mixed with secular activity. Therefore, the secular activity can be regulated by the government by enacting laws. Indeed, Your Lordship. Much obliged. Your Lordship, if the Honorable Bench is convinced, may the Council seek permission to go to issue number 4. Much obliged, Your Lordship. Your Lordship, the refusal to give adoption rights to LGBTQ couples violates their fundamental rights under Article 14, as the classification is arbitrary, under Article 15, as such is discriminatory, and it's violative of the freedom of speech and expression under Article 19(1)(a), and it is also violative of Article 21, as the Adoption Regulation 2022 does not qualify as a valid procedure established by law. Your Lordship, Section 57 of Juvenile Justice Act has no such specification as to whether only a marital couple could adopt. However, Section 5, subsection 3 of Adoption Regulation 2022 mentions a specification making it ultra vires of the Juvenile Justice Act. Lordship, the judiciary plays a crucial role in clarifying the ambiguous area through liberal and purposive interpretation. The provisions of Juvenile Justice Act should be construed as to mean and to include the homosexual couples, and as Section Adoption and Regulation 2022 are ultra vires of Juvenile Justice Act, and hence such a classification is based on invalid legislation and hence manifestly arbitrary. Your Lordship, it is also a violation of Article 15 as such a classification is discriminatory because here the differentiation is solely based on the sexual orientation and thus such a regulation is violative of Article 15. It is also violative of Article 19(1)(a) as it was held by this Honorable Court that in National Legal Service Authority versus Union of India 2014 that this court that the expression of gender identity is a form of protected expression under Article 19(1)(a), and here the classification of the regulation is solely based on the sexual orientation. Therefore, the restriction is arbitrary and there is no legitimate social purpose that is being served by such discrimination. Your Lordship, the refusal to give adoption is also violative of Article 21 as the Adoption Regulation 2022 does not qualify as a valid procedure established by law. Your Lordship, in case of Menka Gandhi versus Union of India, a seventh judgment made that any law interfering with the personal liberty of the citizens must satisfy a triple test that it must prescribe a law. The procedures must withstand one or more the test of Article 19 as suitable or applicable to the situation, and it must be liable to tested under Article 14. Your Lordship, it is humbly submitted that in this impuncate, the denial of becoming adoptive parents under Juvenile Justice Act stems from Adoption and Regulation Act, which is itself an invalid enactment, and as it ultraviolates the parent statute, and hence there lies no procedure established by law. Moreover, it also does not pass the test of classification under Article 14 and the dual test of reasonability. Hence, Adoption Regulation Act does not qualify as a valid procedure established by law. Your Lordship, if the Honorable Bench is convinced, may Council proceed to issue number 5.
Yes.
Much obliged, Your Lordship. Your Lordship, it is humbly submitted that a denial of such claim, LIC claim, to Monica is an absolute violation of her basic human rights and fundamental rights, as it violates, it is violative of Article 14. It is evident here when Insurance Act and the concept of insurable interest was introduced, there was no such concept of unmarried living relation or unmarried couple. However, with the passing of time, such a concept has evolved, and by now applying the concept of by the principle of updating construction, homosexual couples should be included as nominee under Insurance Act. Further, there is no legitimate state purpose that is being served here. Your Lordship, uh, something that stems from an arbitrary action is itself an arbitrary, and the denial of valid marriage certificate is only based violates the
What's
rights under Article.
number two? You are reading something. What is the status of a nominee? This is with regard to receiving insurance claim on the basis of a nomination executed by the person who has created this insurance. Who has formed the insurance.
Individual.
Correct. What is the status of a nominee?
So they were the petitioner is claiming that
Ask you, you should tell whether you know or you do not know. What is this? The question, it's a like mathematics. There is nothing to think.
the petitioner is coming. She is the wife, and hence
Do you mean to say that even if only a nominee, a wife can be a nominee, that other persons cannot be nominee?
no, Your Lordship, a beneficiary.
So listen, nominee is a trustee, correct? Anyone can be a nominee in respect of an insurance policy, irrespective of the relationship with the insurer. Is that So it has no bearing with the relationship of the individual. A nominee is a trustee, and he doesn't acquire right over the insurance benefits. He has on the basis of a nomination, he has the right to receive it. On the natural course of succession, if he is entitled to, he will get it, or else he will distribute it among the entitlements or other persons who are entitled to. Correct? So,
Your Lordship.
Go
In
ahead.
addition to what Mr. Rath has said, please come to your page Roman 11:12. There you have described Monica as an individual, not as the wife of Chandler. So what my learned brother, Mr. Rath, was pointing out, Monica is entitled to her claim as an individual, not as the wife of Chandler. I'm just trying to
Yes.
add to what he has said. So your facts show that Monica as an individual is claiming this right, not as the wife of Chandler.
Yes, indeed, Your Lordship.
Okay, please proceed. Huh? Please proceed.
Your Lordship, the Council is pleasure to learn from this honorable bench.
No, no, it's okay. Please proceed.
Your Lordship. Your Lordship, and the denial of LIC claim also violates Article 15, as such a denial is solely based on the basis of sexual orientation, thus it is discriminatory. Your Lordship, and it is also violative of Article 21, as it violates the right to a dignified life to Monica. Your Lordship, in this impugned case, the denial of LIC claim situates Monica in such a position that she would unable to meet her financial requirements, which interferes in her right to quality of life, and thus it also violates her right to dignified life under Article 21 of the Indian Constitution. Your Lordship, if the Honorable Bench is satisfied with the submission of the Council, may the Council proceed to the prayer.
Yes.
Much obliged, Your Lordship. Whereof, in the light of issues raised, argument advanced, and authority cited, it is humbly prayed that may the Honorable Court be pleased to uphold that the PILs are maintainable before this Honorable Court, declare that it is feasible to implement Uniform Civil Code in Silverland, declare that Uniform Civil Code, being a constitutional mandate, needs to be implemented, declare that refusal to give adoption rights to Chandler and Monica is a violation of fundamental rights under Article 14, Article 15, Article 19, and Article 21, uphold that denial of LIC claim to Monica infringes her fundamental rights guaranteed under Article 14, Article 15, and Article 21, and pass any other order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the petitioner is duty bound shall ever pray.
Thank you.
Much obliged, Your Lordship.
Mr. Rath, any questions, Mr. Rath?
No, there is no more questions from my side.
Your Lordship.
Okay, thank you.
Much obliged. Your
Thank you.
Lordship. Thank you, Lordship.
My lordship, you had asked for the statement of facts, my lordship.
Yes, yes.
This council would like to address the court with the statement of facts, my lordship. My lordship, Silverland happens to be a deep-rooted tradition country, and in which Port Bay is a part which has already implemented UCC in its state.
Let me tell
My
you,
lordship.
speaker number one, let me tell you, since you are all upcoming people who are trying to be lawyers, every case has a fact. There can be no law without a fact, correct?
Indeed, my lordship.
So keep it in mind that whenever you are placing a case, first place the facts before the court.
Indeed, my lordship.
For fact, the court can't appreciate the law without having fact with it. Correct. So bear it in mind that in future you will always place the fact first. You see the fact, then you develop the law and all other things, whatever you like to. Correct. I think my learned brother will agree with me.
Yes, definitely, definitely.
My lordships, it was an honor learning from this court. My lordship, can I continue?
Yes.
May the council continue? My lordship, Port Bay, which was formerly under the Portuguese rule, is the only place in Silverland that has adopted Universal Civil Code. My lordship, in 2018, a significant judgment was passed decriminalizing same-sex relationships, and in that country, Chandler and Monica, named who are a trans man and a trans woman, have been in a relationship and later got married. My lordship, but they were denied for the registration of their marriage and to adopt a child as a couple by the Centerparks administrative bodies. Following this, they filed a PIL for seeking recognition of their marriage, right to adopt, recognition of UCC, and to declare same-sex marriage valid, my lordship. An organization in tandem, in very much in Silverland, championing Muslim women rights, named One Code Movement, filed a PIL emphasizing the disparities Muslim women faced compared to their counterparts. Even though Silverland is a ruling, even though Silverland's ruling body was inclined towards unified legal code, they expressed about the LGBTQ marriages, citing religious tenets. The Silverland Religious Union also opposed their marriage, my lordship. And here the state further raised questions on the viability of Chandler and Monica's PIL, as they had other remedies according to the state, my lordship. And unfortunately, Chandler died within that span. And in order to secure a future, Chandler had invested in a premium LIC, making Monica as the sole beneficiary in this thing. But now, when Monica is wanting to claim that bond's benefit, she is denied asking her for the marriage certificate, which she clearly does not have, as the state has not recognized their marriage yet, my lordship. Hence, the Supreme Court has clubbed both the PILs, my lordship.
Okay. Okay. Thank you.
Fine.
Yes, your lordship.
Coordinator, please proceed further. Avinash. Are you there, Mr. Avinash?
Yes, sir. Yes, sir. Sir, actually, due to some technical error, it was not audible.
Okay. Okay. Let's go ahead.
Indeed, sir. So, with the due permission of the court, we'll be starting with the respondents.
Yes.
Indeed, your lordship, sir. Whereas the speaker 1 will be taking 15 minutes, and speaker 2 will be taking 15 minutes, and 5 minutes there for the rebuttal.
It's up to them to take the decision.
Indeed, indeed.
Greetings of the day, your lordships. If your lordships are satisfied with the statement of fact as presented by the petitioners, Council Speaker 2 would like to proceed with issue number 1 and 2, and my co-counsel, that is Speaker number 1, will deal with issue 3, 4, and 5 from the respondent side.
So if you are satisfied that they have spoken all the facts correctly, then no need of repeating it. If you are not satisfied that they have left over any fact or anything else to be added, then you can add it.
Your lordship, council would like to move ahead with the arguments advanced.
Correct.
Your lordship, before we start, it may be noted that Speaker 2 would be dealing with issue 1 and 2, and Speaker 1 would be dealing with issue 3, 4, and 5 from the respondent side.
Okay.
Much obliged, your lordship. If the bench may permit, council would like to move ahead with issue 1.
Yes.
Much obliged. Issue 1 is, are both the PIL maintainable in the Supreme Court of Silverland or not? And is it feasible to implement a uniform civil code in a nation like Silverland? It is most reverently contended before the Honorable Apex Court of Silverland that this instant public interest litigation is not maintainable under Article 32 of the Constitution of Silverland. And the same issue would be dealt by the council in a twofold manner. First, that is, public interest litigation is not maintainable, and second, it is not feasible to implement uniform civil code in the country of Silverland. Moving ahead with the first leg of the argument, as already stated in the case of Bihar Public Service Commission versus Syed Hussain Abbas Rizvi and another, the expression public interest must be strictly construed so as to justify the denial of the statutory exemption. But in the instant case, the trans couple approached the court with a personal interest and is seeking registration of marriage and insurance claim, which does not involve public interest. And the same case is more likely a publicity interest litigation, because in a very recent judgment by the Supreme Court, that is Supriya Chakrabarti versus Union of India, court has already given its assent about granting right to marry or to LGBTQIA plus community or not. Moving ahead, it is submitted that there is no violation of fundamental rights of LGBTQI community, As held in Supriya Chakrabarti and another versus Union of India AIR 2023, that merely because something holds importance to an individual does not automatically become the fundamental right. And and the judgments relied by the petitioner, that is Navteej Singh Johar, Shafeen Jahan, it is stated that right to union is a fundamental right, but right marriage is a union definitely, but right to marry is not a fundamental right under Article 21. It is further submitted that in the case of Charanjit Lal Chaudhary versus Union of India, while talking about Article 14, Supreme Court contended that all persons are not equal by nature, attainment, or circumstances. So, a mechanical equality, like introducing UCC in the state of Silverland, may result in injustice. Thus, the guarantee against the denial of equal protection of law does not mean identical and the same rules. In the case of Bijoy Emmanuel versus State of Kerala, this honorable court stated that freedom of religion and expression would be violated if UCC will be implemented. And the same is not possible without violating the right of freedom of speech and expression of different religions as well. In the case of Maneka Gandhi versus Union of India, it stated that Article 21 can only be that is right to life can only be violated according to procedures established by the law, but we have to also keep in mind the due procedures of the law. If the UCC would be implemented, implementing a UCC in a large country like Silverland would be arbitrary and oppressive, and it would not be fair and reasonable for the citizens of India. Moving ahead, it is humbly submitted that alternative remedy has not been exhausted by the petitioners in the present case. In the case of Assistant Collector of Central Excise versus Jensen Oseri Industries, this honorable court contended that where there lies the existence of an alternative remedy, the apex court should not interfere unless it is evident that there is no alternate remedy. In this case, cases like this will just lead to the cloggings of court and would waste the would waste the precious time of this court. Article 32 of the Constitution should not be revoked for such frivolous matters, and it merely takes up the valuable time of this honorable court. Moving ahead with the second leg of the argument, that is, implementation of UCC would not be feasible in a country like Silverland because under Article 25 and 26 of the Constitution, the freedom to manage and conduct the religious affairs is granted to every citizen in our country, and from any religious domination they may belong to. UCC would curtail religious freedom and such rights as granted under Article 25 and 26 of the Constitution. In case of In Re, the Kerala Education Bills 1957, this honorable court stated that directive principles of state policy is not enforceable in the court of law. The directive principles laid down in Part 4 cannot override fundamental rights guaranteed by the Constitution. But if UCC would be implemented, it would override the fundamental rights enshrined under Article 25 and 26 of the Constitution. Further, it is stated that in the case where Supreme Court interfered in Shaira Banu versus Union of India, Supreme Court stated that what also needs to be recorded that also in the judgment of John Valamotam case, the matters of the nature that need to be the matters of these natures is need to be dealt through legislations, and such as the view expressed above the judgment cannot be of any assistance to the petitioners in that case of Shaira Banu. It does not matter Supreme Court comes out with a regulation or not, laws have to be made by the legislatures themselves. Further, it is stated that such contentions UCC would not be feasible because it would violate the doctrine of separation of power. As in the case of Devki Nandan Agarwal versus Union of India, the Honorable Court stated that the power to legislate has not been conferred on the courts. The courts cannot add word to a statute or read words into it which are not here. Court shall decide what the law is and not what it should be. Such implementation is the work of legislature, Your Honor, not judiciary. Moving ahead, If your lordships are satisfied with the submissions for the first issue, council would like to seek permission to move ahead with the second issue.
The that you said about alternate remedy, that
Yes, your lordship.
availability of alternate remedy will debar the petitioner to approach the constitutional court, which is that leading judgment. Right.
Assistant Collector of Central Excise.
Irrespective of availability of an alternate remedy, whether a petitioner can approach a constitutional court or not. My question to you is, irrespective of availability of an alternate remedy, whether a petitioner or a person can approach the constitutional court or not.
If the violation of if there is a violation of fundamental right and which is very gross in nature, of a petitioner can approach the Supreme Court, and if the case involves a right which should not.
You need a complete
Yes.
reading about that, correct? You need a complete reading, comprehensive preparation about that. That's not the only ground on which a person can approach the constitutional court. There are other judgments. You can go through Whirlpool's case, 1998, volume 8, SEC, page 1. Correct? Whirlpool's case. There, the Supreme Court says that where the order is passed completely without jurisdiction, correct, in violation of principles of natural justice, a person can approach the writ court directly, irrespective of availability of an alternate remedy. And there are also two more conditions there.
It's an honor to learn from this bench, your lordship. Council would seek permission to move ahead with the second issue.
Yes. If
Much
my
obliged, your lordship.
senior brother will ask any question,
No, it's okay. Please, but
Much
don't,
obliged, your lordship.
don't forget to read Whirlpool, which my learned brother has pointed out. Whirlpool about conditions in which alternative remedy will not be an absolute bar. Okay.
It's an honor
There you have
to learn
natural
from you.
justice. There you have natural justice. There you have violation of fundamental rights. There you have lack of jurisdiction, or if the bias of the statute is challenged.
yes.
Okay, just go through it. Huh? It's for all of you, not only for you. Okay, please proceed. Huh?
It's an honor to learn from this bench, your lordship. Moving ahead with the second issue, that is whether same-sex marriage can be recognized legally and does Constitution protect their rights or not. It is humbly submitted on the behalf of respondents that same-sex marriage cannot be recognized legally and such rights are not protected by the Constitution, as right to marry is not a fundamental right. The same issue would be dealt in a twofold manner by the Council, that is, first, same-sex marriage cannot be legally recognized, and the second, that the Constitution does not protect right to marry. Moving ahead with the first leg of the argument, as in the case of Mr. X versus Hospital Z, AIR 1998, it is stated that Supreme Court defined marriage as marriage is sacred union, legally permissible of two healthy bodies of opposite sexes. It has to be mental, psychological, and physical union. When two souls thus unite, a new soul comes into existence. This is how life goes on this planet. Concept of marriage is governed by personal laws of the citizens and the religious and the customary laws. The modernization of the code has led to codification of the personal laws, but it still keeps into mind the collective wisdom of the nation and cultural ethos of the country as well. Moving ahead, same-sex marriage is not recognized under any uncodified personal laws or any codified statutory laws in the country of Silverland. Granting recognition and conferring rights to recognizing human relations is a consequences in law which should be done by the legislature, not the judiciary. Also, granting such rights by the granting right to marry have many consequential rights such as right to maintenance, divorce, and other ancillary rights as well, which should be taken into consideration by legislature, not a judicial bench. As also held in the case of Supriya Chakraborty and another versus Union of India, that there are almost intractable difficulties in creating through judicial dikkat a civil right to marry or a civil union no less of a kind that is sought by the petitioners in these proceedings, ordering a social institution or rearranging existing social structures by creating an entirely uh, new form of parallel framework of non-heterosexual couple would require conception of entirely different code, which can be done by legislature themselves only. If such rights are violated to LGBTQI community right to marry, then there would be so many. Then it would violate other existing laws like degrees of prohibited relationship, conditions of a marriage, ceremonial and ritual requirements. Moving ahead, talking about the judicial intent, in the case of Hindu Marriage Act or other family laws and other penal laws governing institution of marriage, usage of words such as husband and wife, male and female, bride and bridegroom, father and mother, minor son, minor daughter, it shows that judiciary has an intent of granting such rights to heterosexual couples only. As stated in the case of Raghunath Rai Bareja versus Punjab National Bank, the first and the foremost principle of interpretation of the statute should be the literal rule of interpretation unless it is ambiguous. Here, usage of the words male and female, husband and wife, it is very clear. The intent of the legislature is very clear. Hence, it should be interpreted literally. In Prakash Nath Khanna versus CIT, the language employed in a statute should be determinative factor of a legislative intent, and whatever personal laws are framed has a legislative intent behind which should be furthered in the country. Also, in the case of Delhi Finance Corporation versus Rajiv Anand, it was stated that assuming that there is a defect or an omission in the words used by the legislature, the court cannot correct or make up for the deficiency, especially when a literal reading thereof produces an intelligible result, which is totally there in this case. Reading down, also, the reading down of the laws cannot be done in this case, like stated in the case of Subramaniam Swamy versus Raju, that uh, court cannot the court cannot interfere in the laws unless it is indefinite and unambiguous. Moving ahead, moving ahead, as the mentioning of the word husband and wife under the General Clauses Act, if we do not follow that definition, it would violate so many sections from different laws like 376B, section 498, section 498A of Indian Penal Code, the Domestic Violence Act, Dowry Prohibition Act, and section 125 of Criminal Procedure Code as well. Moving ahead with the second leg of the argument, Constitution does not. Your Lordship, Council would like to seek permission for an extension of 3 minutes.
Is it permissible? 16. I don't know.
Yes, sir. If on the discretion of the court, if we want to
Yeah.
proceed, we can.
Okay. Proceed. Let her proceed. Huh?
Indeed,
Much
sir.
obliged, Your Lordship. So moving ahead with the second leg of the argument, right to marry is not a fundamental right. As stated in the case of Supriyo versus another versus Union of India, all the decisions relied on by the petitioners, that is K.S. Puttaswamy, Navteej Singh Johar, Shakti Vahini, Deepika Singh versus Central Administrative Authority, they recognize right to union as a fundamental right, but not right to marry as a fundamental right. It is further substantiated that in the case of Safin Jahan versus Ashokan KM, the word person of one's own choice used therein cannot be read in absolute terms and must be circumscribed by the law laid down by the parliament. Hence, the personal law should be followed in its entirety. The law may regulate the conditions of a valid marriage, and it may regulate the situations in which a marital tie can be ended or annulled. Moving ahead, it is also submitted that denial of such rights does not violate their fundamental rights, because under Article 14 there is a clear intelligible differentia between heterosexual and people from LGBTQI community. And the object sought by the law here is ensuring social stability and recognition of marriage, which is also met, because still there is a lack of law by the legislature to ensure how the society would be stable if such rights would be granted. Moving ahead, it does not also violate Article 15 on the grounds of discrimination of sex, because only heterosexual couples have the right of registration of marriage. Though heterosexual live-in relationships are recognized indeed, but as in the case of Badri Prasad versus Director of Consolidation, it was stated that live-in relationships and the presumption of marriage is rebutable. So it proves that only heterosexual marriage can be registered. There is no discrimination on the basis of sex. This would be all for issue 2 by the council.
Thank you. Thank you.
Greetings
Yes.
of the day to this honorable bench.
Yes, speaker number 1, you start.
Greetings of the day to this honorable bench. If your lordships permit, speaker number 1 would like to proceed with issue number 3.
Okay.
Yeah, please.
Yes, Your Lordship. Your Lordship, issue number 3 talks about, does the UCC infringe upon the individual's fundamental and personal rights which are protected by the Constitution of Silverland, and does it represent an overreach of state into personal laws of its citizen? Your Lordship, this particular argument by speaker number 1 would like to be substantiated in twofold manner, where speaker number 1 would be showing that there is a violation of fundamental rights of individuals if UCC is brought in, and that there is an interference of state in the realm of personal. There can be interference of state, even though there can be interference of state in personal laws. It won't be implementation of UCC still won't be feasible. Your Lordship, moving further with violation of fundamental rights, Your Lordship, Article 14 of the Constitution of Silverland particularly mentions that equals are treated equally and unequal should be treated differently. Your Lordship, to substantiate this argument under Article 14, the counsel for the respondent would first like to delve into the question whether uniform civil code would be any different from any existing personal laws of the land. Your Lordship, as per the Black's Law Dictionary, yes, Your Lordship.
For the court, speaker number 2, you are requested not to take water through a bottle. You can have it through glass. In court, you can have it through glass. That's a kind of courtesy, correct?
That's right.
Yes.
Apologies, Your Lordship.
If you have it through a bottle like this, it looks you may have something else through a bottle.
Drinking something more other than water.
We are really sorry, Your Lordship. The counsels were unaware.
It's a humor. It's a humor. Don't take it seriously,
Humor.
please. But please follow what my brother Mr. Rath has said. Huh? Please.
Indeed, Your Lordship.
Yes, go ahead. Sorry.
Yes, Your Lordship. Your Lordship, further substantiating, the council would like to tell the definition of code, the code as defined as per the Black's Law Dictionary. Your Lordship, a code is a compilation of laws in effect and organized by subjects. Your Lordship, even if such a code is coming with uniformity, at the end of the day, it will be the principles which exist in the personal laws of the land that will prevail, Your Lordships. Your Lordship, taking into consideration one of the state of Silverland, which is the Porto Bay. Your Lordship, the council would like to substantiate that Porto Bay has a UCC currently, which is in parimeteria to the state of Goa in India, Your Lordship. And when, Your Lordship, the council examined the UCC of Goa, it reveals a lot of different aspects on uniformity. For example, uniformity can take different shapes, Your Lordship. It provides a stark reminder that uniformity is not as per se a rights-loaded word, Your Lordship. It can mean uniformity in discrimination, that we are subjected to have discriminatory provision applicable across all religions uniformly, Your Lordship. And UCC pans out differently for different communities in the state of Goa or Porto Bay. Your Lordship, we must not forget that procedures for registration of marriage are different for Catholics as compared to the procedures applicable to non-Catholics in the UCC of Porto Bay. Even if civil registration of marriage has been compulsory for the Porto Bayans, what actually considered marriage is customary and social norms and social standards all across the religious community, and is the religious celebration and reception and the and your lordship paper registration before the government authorities is considered as a mere mandate, your lordship, in everywhere. And your lordship, when the counsel for petitioner were contending that there has been a violation of fundamental right of Muslim women, your lordship, as they were not given equitable chance to be having secular norms, secular laws to protect them, your lordship, as far as maintenance is concerned, section 125 of the CRPC is talking about a secular sense of maintenance which can be availed by Muslim women as well. Your lordship, the very recent legislation by the state, which is Muslim Women Protection of Marriage Act 2019, protects the rights of Muslim women. Your lordship, further, there are various other secular provisions which are actually helping the Muslim women to protect their rights, and council do not see a very wider implementation of UCC. As your lordship, UCC, when UCC is being implemented in the state of in the state of Silverland completely, your lordship, that cannot be implemented by the judiciary. Judiciary, your lordship, has very limited scope to judicially legislate an individual provision. Judiciary cannot exactly legislate an entire code to implement the entire nature of the your lordship UCC, which is sought by the petitioner in the instant case. Your lordship, even if a UCC is implemented, what about the marriages which are not being registered, such as in the tribal communities, your lordships? Tribal community marriages are not registered, yet they are recognized valid. Your lordship, such there are a lot of other contention as per Article 19, Article 21, where citizens have a personal liberty under Article 21 to practice their religion. Also under Article 25, your lordship, Article 25 and 26, where the council says that religion is a matter of faith, your lordship.
Scheduled tribe marriages are not registered. Why? Do you know?
Your lordship?
Why are they not registered? Do you know?
Your lordship, tribal marriages?
Yes.
Your lordship, because tribal people are not well educated about the fact that their marriage needs to have a formal sanction.
Is there no law? Is there any law for that?
Your lordship, although tribal marriages, majority of the tribal marriages are governed under Hindu Marriage Act, and Hindu Marriage Act still...
Hindu Marriage Act?
Yes, your lordship.
Is it applicable to scheduled tribe persons?
Your lordship, some of the scheduled tribe persons actually are getting married under Hindu Marriage Act itself, your lordship.
Go ahead.
Indeed, your lordship. Your lordship, then the council would like to particularly mention that during the Constitutional Assembly debates, the Muslim members of the Constitutional Assembly debates raised this contention that this would hamper the observance of rituals, ceremonies, food, dress, modes of worship, and various other contentions were raised, as UCC was not exactly a format of which is very ideal in nature. And your lordship, as far as interference of state in personal law is concerned, your lordship, council would like to state the case of Lily Thomas versus Union of India, where your lordship, Supreme Court mentioned this very fact that court has no power to give direction for enforcement of DPSP as entailed in chapter 4 of the Constitution, which includes Article 44, your lordships. And apprehensions earlier, as petitioner council mentioned, that Sarla Mugdal case directed the state, in Sarla Mugdal case, your lordship, the court directed the Ministry of Law and Justice to get a status on what is the status of implementation of UCC in the state. But your lordship, the court again retracted back that statement in Lily Thomas, citing that court should not give direction pertaining to the implementation of such a certain work, which is the complete domain of legislature, your lordship. Similar contentions also has been held in Shabnam Hasmi versus Union of India, and also the ABC versus State of NCT of Delhi, your lordships. And your lordship, also council would like to cite Justice Y.B. Chandrachud in the case of Bachchan Singh versus State of Punjab, where your lordship, Justice Y.B. Chandrachud said that the highest judicial duty is to recognize the limits of judicial power to permit the democratic processes to deal with the matter falling outside those limits, Your Lordships. Your Lordships, if Your Lordships are satisfied with the argument advanced for issue number 3, the Council would like to move to the argument advanced for issue number 4.
Yes, yes, please.
Thank you, Your Lordships. Your Lordships, issue number 4 mentions that is the refusal to give adoption for LGBTQIA plus couple a violation of their rights. Your Lordship, while considering the interpretation of Section 57, Clause 2 of the Juvenile Justice Act itself, a reading of such a provision as a whole makes it amply clear that it intends, Your Lordship, joint adoption only to married couples. Your Lordship, while the word couple is not preceded by married, the use of the spouse later in the sentence rules out that other interpretation. And Your Lordship, principle of nociter suis means that a meaning of a word should be known from its accompanying or associating words, Your Lordship, and is squarely applicable, a provision to be seen as a whole, wherein, Your Lordship, in the case of Superior versus Union of India, where the Superior judgment, where majority judgment cited this honorable bench's case in K. Bhagirathi G. Shenoy and others versus K.P. Balakuraya and another, where it is not sound principle of interpretation of statutes to lay emphasis on one word and disjuncted from its preceding and succeeding words, Your Lordship. And a word is a statutory provisions to be read in collection with its companion words, Your Lordship. And pristine principle based on maxim nociter suis has been relevance, has much relevance in understanding the import of the word in statutory provisions, Your Lordship. And Your Lordship, in the case of X versus Principal Secretary, where the court read down that married woman to be just a woman, Your Lordship, for the purpose of interpreting the MTPA Act, to argue that a similar interpretation to be adopted for the law relating to, Your Lordship, law relating to adoption, Your Lordship. And given the fundamental rights that each childbearing individual has and the objective of the Act, Your Lordship, the sole objective of the Juvenile Justice Act is to protect the interest of the child. And Your Lordship, the CARA regulations are not inconsistent with the JJ Act as mentioned in the previous argument for the same. And Your Lordship, to cite this honorable court in the Superior at Supriya Chakravarti versus Union of India, this honorable court discarded the contention held by the minority judgment that was laid down by Justice D.Y. Chandrachud, where this honorable court read this fact that because the ecosystem of laws as such exists in the current sphere would be unable to guarantee the protection of the said child in the case of breakdown of unmarried couple adopting jointly, Your Lordship. And the best interest of the child is of paramount importance, which is to be protected by this honorable constitution itself. And Your Lordship, there is no particular instances mentioned under the facts where it is clearly mentioned that Monica and Chandler's right to adopt a child was disregarded solely on the basis because they were a transgender couples. Your Lordship, Monica and Chandler, as Superior Chakravarti clearly mentions, that two transgender persons in a heterosexual relationship can marry. But Monica and Chandler, being a transgender couple in a heterosexual relationship, Your Lordships, they had a right to marry. They had a right to get their marriage registration. They had a right to get their marriage registered. But Your Lordship, the bureaucratic hurdles which is mentioned here in the facts very clearly states that Monica and Chandler, Your Lordships, were trying to register their marriage as per their gender identity, not the sex of the individuals. Your Lordship, the personal laws governing Hindu Marriage Act, Special Marriage Act, or Your Lordship, the Muslim Marriage Act per se, only gives a definition of sex per se. It's not giving a definition which is defining gender identity of an individual, Your Lordships. And Supreme Court in Supriya Chakravarti mentioned that two transgender person in a heterosexual relationship where Monica was a Muslim transgender woman, whereas Your Lordship.
Yes. Go ahead, go ahead.
Uh, Indeed, Your Lordship. Your Lordship, Monica was a Muslim transgender woman and Chandler was a Hindu transgender man. Here, Your
You
Lordship,
just
if
said
we,
that Muslim Marriage Act. Do you know what is that act? Any act like Muslim Marriage Act?
Your Lordship,
Muslim Marriage Act. You said Muslim Marriage Act. Is there any
uh,
act available?
Your Lordship, it's Muslim Marriages Registration Act 1981.
Registration Act.
Yes, Your Lordship.
Yes.
Indeed. Your Worship, these marriage acts, these personal laws, any sort of personal laws, give a stricter definition of sex of an individual. Your Worship, there is a wider definition of sex and gender identity. Your Worship, sex is completely based on the biological attributes of an individual. Sex is something which they are born with. But Your Lordship, gender identity is something which they are identifying as per the societal norms and constructs of masculinity and femininity. Your Lordship, here, Monica and Chandler tried to register their marriage. If they try to register their marriage, the Hindu Marriage Act or any marriage act per se would give a definition of sexual only based on sex, where Monica and Chandler registered their sex in wrong columns, Your Lordship. That is why their marriage was discarded in this particular instance, Your Lordship. And hence, they could have had a particular marriage, but they did not deem to take such a right which was available to them, Your Lordship. If Your Lordships are satisfied with arguments for issue number 4, Your Lordship, the Council would like to move to issue number 5.
Yes, go ahead.
Much obliged, Your Lordships. Your Lordships, issue number 5, the Council is dealing that does the denial of the LIC claim to Monica based on the absence of a recognized marriage certificate infringe upon her rights and entitlements as designated by Chandler, Your Lordship? It is humbly submitted that LIC claim do not infringe upon the rights of an Monica, Your Lordship. Claim of a particular insurance money could have been dealt by a consumer court or, Your Lordship, the appellate IRDAI authority, where petitioners have approached this honorable court in a writ jurisdiction. And Your Lordship, this could have been a subject matter, even if not the IRDAI or consumer court, this could have been a subject matter of legal rights violation, which is under Article 226 of the Constitution of Silverland, which is the jurisdiction of High Court, Your Lordship. A claim of a particular insurance money denied, claim of insurance money should have been asked by Monica to the Honorable High Court of this Silverland, Your Lordship. And Your Lordship, the second leg of the argument here is that the Council would be mentioning by stating the case of Balco Employees Union versus Union of India, where Balco Employees Union case held that the court cannot interfere in the policy decisions, and it can do so only if the policy decision is patently arbitrary, discriminatory, or malified. And Your Lordship, in this instant case, the policy consideration which was required while claiming the insurance, Your Lordship, while registering the insurance, Your Lordship, is a contract. Insurance is a contract of indemnity. And Your Lordship, while entering into an insurance contract, the terms and conditions must have clearly laid out the requirement of claims which are to be required by the insurance authority to get that similar claim, Your Lordship. And there has been consensus ad idem binding both the parties to such a claim. But while entering to that insurance contract, Your Lordship, there must have been an instance where Chandler is describing Monica as Chandler's wife, but to claim such a right as a wife, Your Lordship, there needs to be a formal bond of solemnization, which was in turn available to Monica and Chandler, which they did not avail, Your Lordship. As previously stated, the Supriya Chakravarti versus Union of India case very clearly states that two transgender person in a heterosexual relationship can get married, Your Lordship. If Your Lordships are satisfied with the argument advanced for issue number 5, Your Lordship, the Council for Respondents would like to move to the prayer
May
of
I just
the.
ask you a question?
Indeed, Your Lordship.
Yeah, since you are about these gay marriages, what is the present position so far as the Indian Supreme Court is concerned
Your
regarding
Lordship,
gay marriages?
Your Lordship, regarding gay marriages are yet not recognized by the Supreme Court as per the Supriya Chakravarti versus Union of India, Your Lordships. But Your Lordship, Supriya Chakravarti made an exception to transgender persons who are in a heterosexual relationship can get married in that bond, Your Lordship.
Ultimately, what did the Supreme Court do?
Your Lordship, Supreme Court clearly mentioned that the
No. Question. Try to understand the question, then reply. Ultimately, what the Supreme Court is now doing on that?
Your Lordship, they are not allowing same-sex marriages.
No. There is a review petition pending, which is coming out ultimately.
They left
Indeed,
it
Your
to
Lordship.
the legislature. Now a review petition, as my brother said, is pending.
Indeed, Your Lordship.
Are you aware of the genesis of all these gay marriages and decriminalization of Section 377 of the Criminal
Indeed, Your
Code,
Lordship.
which is the main case? Are you
Uh,
all aware of it?
Indeed, Your Lordship. The case began at Delhi High Court in the
Yeah,
case of Naz Foundation. Then
excellent.
it moved to Suresh Kumar Kaushal, where
Correct.
again it was petitioned before the Honorable Supreme Court in case of Navtej Singh Johar versus Union of India.
It's a five-judge bench,
Yes, Your Lordship.
right?
Delivered by Honorable Justice. Judgment is
Deepak Misra, Your Lordship.
Yeah,
Justice.
excellent, excellent.
Excellent. How many pages this Supriya Chakravarti runs? You know that?
Your Lordship, somewhat around 311 pages.
No.
360. Yes, Your Lordship.
And if a person reads 1 page a day, then it takes him 1 year to complete the judgment.
Indeed, Your Lordship. But the Council for Respondents have read the judgment.
I was just in the morning discussing about this. Why are these lengthy judgments being written by the judges? Why? If you
Your
go through
Lordship, because there is a lot of.
no, I am speaking to. If you go through the Privy Council judgments, 1.5 pages. That's all. The whole case, idea, law, fact, proposition, thoughts, everything is there in 1.5 pages. That's all. Starting from 1918 and up to this Privy Council, 1.5 page, maximum 2 pages. If you
Nowadays,
see,
I think on a lighter note, these judgments are more of legal literature than judgments.
no, it's still adding, still just to supplement you. There are mutually inconsistent propositions in these long line of judgments.
Correct.
And in the first part of the judgment, you forget whatever you have said in the first paragraph, first part. Then if you are writing 300 pages, then you are just creating a confusion and a contradiction among yourself.
Maybe the legal assistants are to blame. Should take part of the blame,
Yes.
and their computers.
Yes.
Anyway, let us proceed with our case. It's good that you know about Nas Foundation. It's very heartening to know about it. So that was the genesis of 377, Section 377, and the entire case of this LGBT rights and all that arose of that.
Good.
Thank you very much. You know about it. Please proceed. Huh?
Much obliged, Your Lordship.
No, time is over.
Acha, his time is over. Acha, let us give him 1 minute because we have disrupted him.
Okay. Let us.
Just give
Much obliged, Your Lordship.
Yes. Thank you. Please
Your
proceed.
Lordship, the council would move towards the, if your Lordship's permission, council would move towards the prayer.
Yes.
Your Lordship, wherefore, in the lights of the facts stated, issues raised, argument advanced, and authority cited, it is most humbly submitted, prayed, and implored before this Honorable Supreme Court of Silverland that it may graciously please to adjudge and declare that both the PIL are not maintainable before the Honorable Court of Supreme Court and and the same is liable to be dismissed and is not feasible to be implement UCC. Same-sex marriage should not be legally recognized. Your Lordships, UCC should not be implemented as it infringes individuals' fundamental rights and personal rights. Your Lordship, the refusal to give adoption for LGBTQIA plus couples is not a violation of their right, and denial of LIC claim to Monica based on the absence of recognized rights certificate does not infringe upon her rights and entitlements as designated by Chandler. and or pass any such order, writ, direction as the honorable court deems fit in the interest of justice, equity, and good conscience. For this act of kindness, the respondent shall duty bound pray.
Do not
Thank
ask
you.
for imposition of this cost. Do not like the imposition of heavy cost on the petitioners for filing this frivolous litigation.
Uh, Your Lordships.
Oh,
Thank you.
Your Lordships, if this Honorable Court permits, they can go to the rebuttals if they want, because they have taken 5 minutes for that. Both the team have taken 5 minutes for the rebuttals.
Mhm.
If you both team, with the
yes,
permission of
number
this one.
one, if you like to add anything in reply to that, if you adjourned anything in agenda? No.
Your Lordship, the Council seeks permission to go for the rebuttal.
Yes.
Much obliged, Your Lordship. Your Lordship, in para 3 of the respondent's written submission, they have stated that petitioners have approached the court with a personal interest in seeking the registration of marriage license and issuance of their child's birth certificate. Your Lordship, what is the validity of such contention? Para 8 of the Moot proposition makes it clear that the prayer on the part of petitioner is to legalize same-sex marriage, which vindicates larger public interest of the LGBTQ community. Further, Your Lordship, in the instance case, there is absolutely no cause and concern with relation to issuance of the child's birth certificate. The petitioners are contending that the refusal to give the right to become adoptive parents is the violative of Article 14, 19, and Article 21, which my co-counsel has already established. Your Lordship, in para 11 of their written submission, they have cited a case arguing that the petitioner should have approached the High Court and not the Supreme Court. The Council submits that Article 32 is a fundamental right itself, and the Honorable Supreme Court cannot refuse to consider any petition under Article 32. Your Lordship, in para 17 of their written submission, they have placed reliance on Shaira Banu case and quoted a particular facet of the case where they contend that personal laws of every religion denomination is protected under Article 25. But in the same case, the court relied on the urgency of infusing life to Uniform Civil Code. The court reiterated the same in the Sarla Mudgal versus Union of India, where it held that marriage, succession, and adoption are matters of secular character and must not be kept out of guarantee under Article 25 and Article 26. Hence, an argument constitutes a contempt of court itself, and this challenges the aptitudeness and intellect of the vulnerable institution of the judiciary.
Ratha sir, just excuse me for a minute. Huh?
Yes.
Please continue. Huh?
Yes.
Much obliged, Your Lordship. Your Lordship, in para 29 of the written submission, they have cited Raghunath Rai Bareja versus PNB and contended that the foremost principle of interpretation is the literal rule of interpretation. This argument is again invalid, Your Lordship, as the court has held in the case of Commissioner of Income Tax and Podar Cement Limited that in case of legislative vacuum, a legislation must be constructed with regard to principle of updating construction. Your Lordship, in page 35 of the written submission, in the issue 5.2, the title goes like transgender persons' marriage are recognized under existing law. Your Lordship, what is the validity of such a statement? What's even the ground of saying that? And if that is the case, then why have the petitioners have approached this court? The personal laws conferring in stated that woman is anathema to equality. Personal laws are derived uh, not from the constitution but religious scripture. The law thus derived must consistent with the constitution, lest they become void under Article 13 if they violate. Lastly, Your Lordship, the respondent claimed that life insurance comes under contract of indemnity. Your Lordship, if it comes under contract of indemnity, does the respondent mean that in case of loss occur to a human or a person, we are going to estimate in terms of money? No, Your Lordship, that cannot be the estimation. And that is it, Your Lordship. And it was an honor to argue before this honorable court.
Thank you. I'm sorry.
Your Lordship.
Yes. Is it over now?
That
Sir,
is what.
the respondent side has also taken 5 minutes for the sir rebuttals.
Your Lordships, as the rebuttal covered all the issues dealt by the respondents. Issues dealt by speaker two would be answered by me, and rest would be answered by my co-counsel, if the bench may permits.
Yes.
So, if
Much obliged, Your Lordship. Uh, moving ahead, first contention was paragraph 3. It is already established, Your Lordship, that there is a personal interest in this present litigation of the petitioners of registering their marriage and getting a right to adoption. Hence, it is not a public interest. Moving ahead with paragraph number 11, it is said that. Moving ahead in paragraph 11, in Kanubai Brahmat, it was stated that it would such acceptance of all the PILs would lead to backlog of cases and clogging of courts. And moving ahead with paragraph 17, though in Shaira Banu, state has interfered in personal laws, but the state have also clearly stated that such interference cannot be, such interference will not have any force. At last, legislation has to be dealt through the process of legislature. And moving ahead with other contentions raised, which I believe this that one was in the page number 35. Okay, no. Paragraph 29. It was stated in Raghunath that literal rule of interpretation, first and foremost principle is literal rule of interpretation, but learned counsel from petitioners stated that there are other cases as well where they say if there is a gap in law, they can interpret it. But there is no gap in law. The legislative intent is very clear, and I have also stated in the case of Prakash Nath Khanna versus CIT, if the language employed in the legislature is determinative factor of the legislative intent, it should be followed in that way. Legislative intent is very clear from the several laws that I have submitted in my submissions earlier. And just the assumptions to be made that there is a defect or there is an omission in the law, the court cannot correct and make up for the deficiency, which is also held in the case of Delhi Finance Corporation versus Rajiv Anand of the 2004-11 SCC 625. Moving ahead, in page number 35, as contended by the petitioners, that transgender persons' marriage are recognized under the existing laws. That is through the judgment of Supriya Chakrabarti versus Union of India. Now, my co-counsel will deal with the rest of the rebuttals.
Your Lordship, if your Lordships may permit, the council may begin with the rebuttal.
Yes.
The rebuttal. Your Lordship, particularly when the petitioner counsel mentioned about contract of indemnity, Your Lordship, every insurance contract is a contract of indemnity, but yeah, there is, Your Lordship, a exception that is, Your Lordship, life insurance. Definitely that is agreed. But Your Lordship, at the end of the day, that is again a contract, a promise is made. It falls under the definition of a valid contract, as there is a promise made and that promise needs to be fulfilled by the insurance regulation authority, and it is a contingent contract, Your Lordship. It is on the basis of the death of a person or not even the death of a person. It can happen or not happening or not happening of a event which is dealing with the life insurance particularly, Your Lordship. And Your Lordship, when the counsel for speaker number 1 would like to clarify this particular fact, when counsels, the petitioners have approached this honorable court, both the petitioners are transgender couples who had a right, Your Lordship, under the existing law to get their marriage registered. This is, as per my co-counsel mentioned, it is as per Supreme versus Union of India, where any person in any two transgender person in a heterosexual relationship, Your Lordship, can have a marriage registered under the existing personal laws, which was collectively agreed by the 5-judge bench in the Supriya Chakravarti versus Union of India, Your Lordship. It is the problem on the behalf of the petitioners that they have not registered the marriage as per the columns which were assigned to their sexes, which was currently governed. Current position of the law is stating such a particular intention. And your lordship, as far as UCC is concerned, your lordship, the judicial legislation aspect of UCC was well dealt with. The argument advanced of the council number, speaker number 1 of the respondent council, where speaker number 1 said that if there is a judicial legislation, your lordship, there needs to be a limit to such a judicial legislation. That would be all, your lordships.
Thank you.
Thank you, your lordships.
Sure, just one question for all of you. All of you have quoted K.S. Puttaswamy. Do you know who is he? K. Puttaswamy.
Your lordship,
And what
he's
is
a
the-
retired
Huh?
justice. He is a
Oh,
retired
yes.
justice.
Why is he known for? What did he challenge in the Supreme Court?
Your lordship, privacy, right to privacy.
Or
And
was it the
Article 33.
Aadhaar? Or was it the Aadhaar case?
So, your lordship, it was the other case,
Yes.
but the right to privacy was one of the primary factors.
Aspects.
Aspects. Yes, sir. Yes, your lordship.
In Aadhaar case. Huh?
Yes.
Thank
Your
you. Thank you.
So,
then
Lordships, we extend our deepest appreciation to our